Sexual Offences Act, which is so clear on what needs to be done whenever this happens, right?
Yes.
But here now, with this ruling that has come from the court, we find that the investigative agencies in the criminal justice system, so the ODPP and say the DCI or the police, when they're investigating this, has this just made it more difficult for them to even present a case in court? Because at the end of the day, when you are now investigating, you have to come with a burden of proof. So, because I'm 17, this one is 13, we are still minors, she agreed, he agreed, or he forced. How do you go about it? Is it just now very difficult to prosecute these matters in court?
There is a difficulty, but at least the court asked the different agencies to come up with guidelines. So it asked the Director of Public Prosecutions to come up with guidelines, and the same is expected of the police, the National Police Service. But definitely it leaves them in a difficulty because, for instance, you use the word close in age.
Yes.
So what is close in age? It's not been defined by the court, and this is not the work of the court actually. When it comes to criminal, when it comes to criminal law, it is better left to the Parliament to define for us what is a given offence, what should be the punishment. And I argue that there is need for reform because even within the Sexual Offences Act, the language is it is not very well written. For instance, when they talk about defilement of children, they have classified, and they have one of the third level is where there is an offence for someone who is engaged in who defiles a child between the age of 16 and 18. Now, when you say 18, again, now that goes to the territory of adults.
Adults, yeah.
So I felt clearly here the law should have been properly written to mean between 16 and below 18.
Yeah.
But when they say between 16 and 18, so in 18 is sort of inclusive. And it leaves, you can see there's an issue there also with the legislation, but the courts have only made it worse.
So if we were to talk about a proper reform that would come to address the issue that you're talking about, what would be the correct procedure that would then guide a proper and clearly spelled out way of dealing with these matters?
What I expect the court to do is, upon finding whatever it found in the judgment, it should have asked Parliament, the Attorney General and Parliament, to take action to basically introduce either amendments to the law or just to rewrite the law to repeal and replace the existing legislation. But to just give a declaration and leave it at large, it's very dangerous. But as I said, the original sin is I trace it back to the Supreme Court.
Okay. So there's a problem, right? This is what you're calling the original sin.
Yes.
There was a problem that this ruling essentially was trying to cure, or that the interpretation that led to this ruling was trying to cure. And that, unfortunately, we do have cases where the intent was not criminal, or the intent was not to harm.
Yes.
And so with this, we see that those who may have, because there is a famous case, and because it has been adjudicated on, we can speak about it. There was a young woman, a teacher in this country, who was in a relationship with a young man. He was 17. At the time, she said that she did not know that he was below adulthood because his physical features made him, you would never have imagined that he was underage. And she was then reported, and the case went to trial, went to court, and she was sentenced to 10 years. We have another case where a young man, and he was 17 years old, and the girl that he had sexual relations with was 16. And she got pregnant, and her parents now took this case to court, and he was then sentenced for defilement, statutory rape, all sorts of things were thrown at him. And that was the time that we started to see cases by Justice Odunga, who said, come on, we should be able to deal with this thing better, because the 16 and 17-year-old were clearly in a Romeo-Juliet case, whereby they had a relationship, but the cultural, traditional, outside the box took it to the courts. So we can see what this is trying to cure. Do we see a problem that it obfuscates when you now open the door? Because then what we are saying if we look at this headline, even if it is misleading, what it means now is that your 13-year-old can start to have sex and nobody can ask questions about it. Because how do you then keep it within the lines of criminality?
So let's start with what problem it creates. Actually, there are multiple problems because, as you mentioned, there are teenage pregnancies. And I mean, when you think about it from a large economic perspective, it's a big issue because if you have children who become pregnant, they have a baby, whose responsibility is it to look after this child? So while you say these children can have because in this judgment we're discussing today, the court is saying that perhaps these children, we should not assume that they do not have the capacity to make decisions. It's also talking about what you call evolving change, rather the evolution of the adolescents, that they are undergoing an evolution. But at the same time, they say these people do not have the capacity to access. They don't have the information to have access to reproductive rights. So there's some internal contradiction. If we have to go that way, then we must think about the whole picture. How do we protect these children against getting into pregnancies? If we just say it's an open check, it will become a monster which you cannot control. So as you asked, what should we then do? It's part of this legal reform. We have to, while we are appreciating these so-called Romeo and Juliet situations, we can't just leave it an open door, because it becomes, once you create a loophole in the law, then anybody is allowed to exploit the loophole in the law as long as it's within the law. So it's a problem. We have to just make sure that all these proclamations are taken through the right process. As I said, this is through legislation. It's through policy change. If we talk about policy change, we have to involve all the actors, from, as I said, from the investigatory to the prosecutory agencies. All of them have to be involved to reach a decision that then covers everybody. And then, you remember, Article 10 was mentioned in this judgment. It's one of the values in Article 10 is public participation. We have to involve, it's a national conversation. So part of it, I believe we have started this conversation today, and it should become a national conversation.
You know, I look at it, there is how this will play up in court, legalese, fraternity, and how you understand it. But from a layman point of view, I mean, children should not have sex. You know, children should not have sex.